Section 7 of The Law and Medical Men. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Ian Stewart, Rosanna, Victoria, Australia. The Law and Medical Men by Robert Vashon Rogers. Section 7. Chapter 7. Professional Evidence. It was decided nearly 100 years ago, in the Duchess of Kingston's case, that a medical man has no privilege to avoid giving in evidence any statement made to him by a patient, but that he is bound to disclose, when called upon to do so in a court of justice, every communication, however private and confidential, which has been made to him by a patient while attending him in a professional capacity. This has often been deemed a grievance by medical men and considered a compulsory breach of professional ethics. For the relations between patient and physician being necessarily of a confidential character, communications made to a physician are looked upon by the profession as confessions which should be kept religiously locked in the brain of the physician. Lord Mansfield said, if a medical man was voluntarily to reveal those secrets, to be sure he would be guilty of a breach of honour and of great indiscretion, but to give that information which by the law of the land he is bound to do will never be imputed to him as any indiscretion whatever. A French writer says, the tribunals neither ought nor have they the power to exact from a physician the revelation of a secret confided to him because of his office. At all events, he may and ought to refuse to tell. Religion, probity, nay, the rights of society, make this the law. Still more are we bound to secrecy when not compelled to disclose. Upon this point casuists and jurisconsults are of one opinion. These communications between physician and patient, which may relate to the history of a transaction in which a wound has been received or a particular disease communicated, whenever essential to the treatment of the patient's case, are in some states of the American Union considered privileged communications, which the physician is either expressly forbidden or not obliged to reveal. This is the law in Arkansas, California, Indiana, Michigan, Iowa, Missouri, Minnesota, Montana, New York, Ohio, and Wisconsin. In Wisconsin he is not compelled, and in the other states named he is not allowed to make the disclosure. But in Minnesota the prohibition extends only to civil cases, and in Iowa, Indiana, and Minnesota the seal can be removed by the patient himself. In these states the confession, in order to be protected against disclosure, must relate exclusively to such matters as are indispensable to the professional treatment of the patient. Communications made outside of this sphere acquire no immunity from having been entrusted to physicians, for at common law such are not deemed privileged, and wherever so recognized they are the creatures of statutory enactment. As stated, in some of the above-mentioned states, the party interested may waive the privilege, in which case the communication may be disclosed. But in New York it is expressly enacted that no person duly authorized to practice physic or surgery shall be allowed to disclose any information which he may have acquired in attending any patient in a professional character, and which information was necessary to enable him to prescribe for such patient as a physician, or to do any act for him as a surgeon. Yet even there the statute will not be construed so as to shield a person charged with a crime, instead of being a protection to the victim, the patient. The seal upon the physician's lips is not taken away by the patient's death. Necessarily all communications to be privileged must be of a lawful character, and not against morality or public policy. Hence a consultation as to the means of procuring an abortion on another is not privileged, nor, by parity of reason, would any similar conference which was held for the purpose of devising a crime or evading its consequences. It must appear not only that the information was acquired during professional attendance, but was such as was necessary to enable the physician to prescribe. It is for the party objecting to show that the information sought to be obtained is within the statutory exclusion. It will not do to extend the rule of exclusion so far as to embarrass the administration of justice. It is not even all information which comes within the letter of the statute which is to be excluded. The exclusion is aimed at confidential communications of a patient to his physician, and also such information as a physician may acquire of secret ailments by an examination of the person of his patient. The policy of the statute is to enable a patient, without danger of exposure, to disclose to his physician all information necessary for his treatment. Its purpose is to invite confidence and to prevent a breach thereof. Suppose a patient has a fever, or a fractured leg, or skull, or is a raving maniac, and these ailments are obvious to all about him. May not the physician who is called to attend him testify to these matters? Before information sought to be obtained from physicians, witnesses, can be excluded, the court must know somewhat of the circumstances under which it was acquired, and must be able to see that it is within both the language and the policy of the law. A report of the medical officer of an insurance company on the health of a party proposing to insure his life is not privileged from production, nor is the report of a surgeon of a railway company as to the injuries sustained by a passenger in an accident, unless such a report has been obtained with a view to impending litigation. Representations made by a sick person of the nature and effects of the malady under which he is suffering are receivable as original evidence, whether made to a physician or to any other, though, if made to a physician, they are entitled to greater weight than if made to a man incapable of forming a correct judgment respecting the accuracy of the statements, from unacquaintance with the symptoms of diseases. When this bodily or mental feelings of a party are to be proved, his exclamations or expressions indicating present pain or malady are competent evidence, and the complaints and statements of the injured party, if made at the very time of the occurrence, are admissible as res gestae, not only as to the bodily suffering, but as to the circumstances of the occurrence. And the time in question is not the time of injury, but the time when it is material to prove a condition of bodily or mental suffering, and that may be material for weeks and perhaps months after an injury has been inflicted. The statements are admissible even though made after the commencement of an action, though this may be a circumstance to detract from the weight of the evidence of a physician, so far as it was founded on the statements. But statements or declarations of a sick or injured person, referring to his state and condition at a time past, and not furnishing evidence of a present existing malady, are to be carefully excluded, whether made to an expert or a non-expert, and statements in writing by patients to a medical man, describing the symptoms of the illness upon which the physician has advised the patient, are also inadmissible in evidence. It has been said in Illinois that as a physician must necessarily, in forming his opinion, be, to some extent, guided by what the sick person may have told him in detailing his pains and sufferings, not only the opinion of the expert, founded in part upon such data, is receivable in evidence, but that he may state what the patient said in describing his bodily condition, if said under circumstances which free it from all suspicions of being spoken with reference to future litigation and give it the character of res gestae. On the other hand, in Massachusetts, in an action for personal injuries, a surgeon who had attended plaintiff was held competent to testify as to plaintiff's condition from what he saw, but not from anything the patient told him. A physician testified that the plaintiff stated she had received a blow in the stomach. The court said that it would clearly have been competent for the physician, after having testified to the plaintiff's condition and to the complaints and symptoms of pain and suffering stated by her, to have given his opinion that they were such as might have been expected to follow the infliction of a severe blow. But it was not competent for the physician to testify to her statement that she had received a blow in her stomach. And in Tennessee, the statement made by a man when his wounds were being examined, as to who made them, or as to the instrument with which they were inflicted, was deemed inadmissible. Memoranda, although not legal instruments in the proper sense of the term, have been considered as an inferior class of records, and as such entitled to some standing in courts. Such minutes of past facts may be used by experts while under examination, but only to refresh their memory and not to take its place. For this purpose they may use written entries in notebooks, or even copies of them, provided always they can swear to the truth of the facts as there stated. Yet, if they cannot from recollection speak to the fact any farther than as finding it stated in a written entry, their testimony will amount to nothing. It is not necessary that the writing should have been made by the expert himself, nor even that it should be an original writing, provided, after inspecting it, he can testify to the facts from his own recollection. The English and American authorities agree that medical or other scientific books are not competent evidence in courts of law. They cannot be put in evidence, although the medical witnesses state that such works are works of authority in medicine. Tyndall, C.J., thought that witnesses might be asked whether in the course of their reading they had found such and such a rule laid down. They might be asked how far their opinion was founded on books, and might refer to such books. They might be asked their judgment on the point, and the grounds of it, which may be in some degree founded on those books as part of their general knowledge, but the book itself could not be read, and as late as 1875 Mr. Justice Brett refused to allow Taylor's medical jurisprudence to be read to the jury, saying, "That is no evidence in a court of justice. It is a mere statement by a medical man of hearsay facts of cases at which he was, in all probability, not present. I cannot allow it to be read." And the refusal seems to be the rule in England. And Redfield, C.J., says that when objected to, these books have not generally been allowed to be read in the United States, either to the court or jury. And a very recent writer says, "The result of the cases on this subject shows clearly that the very decided weight of authority is against the admissibility and evidence of standard medical treatises." Such is the rule in England, Ontario, Indiana, Maine, Maryland, Massachusetts, Michigan, North Carolina, Rhode Island, and Wisconsin, supported by dicta in California and New Hampshire, and opposed by decisions in Alabama and Iowa. In Iowa and Wisconsin, such books have been allowed to be read, the court in one case remarking, "The opinion of an author, as contained in his works, we regard as better evidence than the mere statement of those opinions by a witness, who testifies as to his recollection of them from former reading. Is not the latter secondary to the former? On the whole, we think it the safest rule to admit standard medical books as evidence of their opinions upon questions of medical skill or practice involved in the treatment." In Wisconsin, however, the court seems now to have overruled its earlier decisions and to have sided with the majority. In Illinois, a witness may, to test his knowledge, be cross-examined as to his reading of particular authors upon the subject, and as to whether reputable writers do not entertain certain views upon the subject. Paragraphs from standard authors, treating of the disease in question, may be read to the witness, and he may be asked if he agrees therewith, as one of the means of testing his knowledge. But care should be taken by the court to confine such cross-examination within reasonable limits, and to see that the quotations read are fairly selected so as to present the author's views. Mr. Rogers questions the wisdom of this decision. The witness, however, cannot read from a scientific work in his examination in chief, though he be an expert, and agree with the views expressed by the author. Nor can a passage from a book be got before a jury as evidence in an indirect manner, when it cannot be read to them. So it was decided where a medical man was asked if he was acquainted with a certain book. He replied that he had heard of it, but had not read it. He was then asked whether it was considered good authority, and he said it was. He was then asked to read a certain paragraph. This he did, and was recalled. Counsel then read from the book the same paragraph, and asked if such a case as that stated was reported. Held to be error. And in Ontario, it has been held improper to ask medical witnesses, on cross-examination, what books they consider best upon the subject in question, and then to read such books to the jury, but they may be asked whether such books have influenced their opinion. Although as a rule scientific books cannot be read to a jury as evidence, they may be read to discredit the testimony of experts who claim to be familiar with them, and refer to them as authority. Where one borrows credit for his accuracy by referring to books treating of the subject, and by implying that he echoes the standard authorities, the book may be resorted to disprove the statement of the witness, and to enable the jury to see that the book does not contain what he says it does, and thus to disparage the witness, and hinder the jury from being imposed upon by a false light. It has been held again and again that scientific books cannot be read by counsel to the jury as part of their argument. Shaw, C.J. of Massachusetts, says, "Facts or opinions cannot be laid before the jury except by the testimony under oath of persons skilled in such matters." Again, where books are thus offered, that is, to be read in argument, they are, in effect, used as evidence, and the substantial objection is that they are statements wanting the sanction of an oath, and the statement thus proposed is made by one not present, and not liable to cross-examination. If the same author were cross-examined and called to state the grounds of his opinions, he might himself alter or modify it, and it would be tested by a comparison with the opinions of others. Medical authors, like writers in other departments of science, have their various and conflicting theories, and often defend and sustain them with ingenuity. But as the whole range of medical literature is not open to persons of common experience, a passage may be found in one book favourable to a particular opinion, when, perhaps, the same opinion may have been vigorously contested and, perhaps, triumphantly overthrown by other medical authors, but authors whose works would not be likely to be known to counsel or client, or to court or jury. Besides, medical science has its own nomenclature, its technical terms and words of art, and also common words used in a peculiar manner, distinct from the received meaning in the general use of the language. From these and other causes, persons not versed in medical literature, though having a good knowledge of the general use of the English language, would be in danger, without an interpreter, of misapprehending the true meaning of the author. Whereas a medical witness could not only give the fact of his opinion, and the grounds on which it is formed, with the sanction of his oath, but would also state and explain it in language intelligible to men of common experience. If it be said that no books should be read, except works of good and established authority, the difficulty at once arises as to the question, what constitutes good authority? In an English case, counsel, in addressing the jury, attempted to quote from a work on surgery. Alderson B. would not allow him, saying, "You surely cannot contend that you may give the book in evidence, and, if not, what right have you to quote from it in your address, and do that indirectly which you could not be permitted to do in the ordinary course?" In Massachusetts, North Carolina, Michigan, California, and New York, similar decisions have been given, and in giving the dissenting opinion in State and Hoyt, Loomis J. said, "Books may be crazy as well as men, and all sorts of theories relative to responsibility for crime are advocated in books. Courts do not take judicial notice of standard medical or scientific works, and the standard works of today may not long continue such, owing to new discoveries and advancing knowledge." In this case, the question was as to reading medical books on insanity on trials where the question of insanity arose. The book was Ray's Medical Jurisprudence of Insanity. In a still later case, it was held to have been error for the attorney on the argument to read to the jury extracts from Brown's Medical Jurisprudence of Insanity. The court said that it is peculiarly important that a defendant charged with a crime should be confronted by the expert witnesses against him, and that they should be cross-examined in his presence. But when the opinions of a writer are permitted to go to the jury, the writer is not sworn or cross-examined. If held admissible, the question of insanity may be tried, not by the testimony, but upon excerpts from works presenting partial views of variant and perhaps contradictory theories. In Connecticut, however, in a murder case, the court, Loomis J. and Park C.J., out of the 5 judges dissenting, held that standard medical works on insanity might be read to the jury by the counsel for the accused when discussing the question of his insanity. It was said that in this jurisdiction, that of Connecticut, for a long series of years, counsel have been permitted to read to the jury, as a part of their argument upon this part of their case, extracts from such treatises as by the testimony of experts have been accepted by the profession as authority upon that subject, such treatises as have helped to form the opinion expressed by the expert. The practice by repetition has hardened into a rule. In Indiana, it was held that if the extracts were merely argumentative and contained no opinions that could be regarded as properly matters of evidence, they might be admitted, subject to the instructions of the court as to the law of the case, and under the warning that they were not evidence. In Texas and in Delaware, similar decisions have been given. And in Ohio, where, at the trial of a cause, counsel was forbidden to read to the jury Youatt's work on veterinary surgery, the court on appeal said, "It is not to be denied, but that a pertinent quotation or extract from a work on science or art, as well as from a classical, historical, or other publication, may, by way of argument or illustration, be not only admissible, but sometimes highly proper, and it would seem to make no difference whether it was repeated by counsel from recollections or read from a book. It would be an abuse of this privilege, however, to make it the pretence of getting improper matter before the jury as evidence in the cause." As it did not appear that the proposed quotation was relevant, or came within the appropriate and legitimate scope of the argument, or that the party was injured by its exclusion, the court would not reverse on this ground. Where the reading is allowed, it seems to be considered a valuable privilege, yet so susceptible of abuse that the extent and manner of its exercise must be entrusted in a great measure to the sound discretion of the court. Not a practice ever sanctioned directly or indirectly by the court, nor one which has generally been considered by the judges as of binding force in law, but rather a subject to the discretion which, it is true, has been usually exercised in favour of the accused in capital trials. Where the exclusion rule obtains, counsel in addressing the jury has no right to quote the opinions of medical men as given in their works. If they do, it is the duty of the court to instruct the jury that such books are not in evidence, but theories simply of medical men. But there is no question that, under all circumstances, books of science may be read in argument to the court. Medical men are often called to give evidence as to dying declarations where there is a charge of homicide, and where the cause of the death of the declarant is the subject of the declaration. They should remember that the declaration will not be admissible unless the deceased was conscious of approaching death, and made it under a sense of his impending doom. Any hope of recovery, however slight, renders the declaration inadmissible, and the question turns rather upon the expectation of death at the time of making the declaration than upon the interval between it and the death. An entry made by a medical man in the course of his profession is admissible in evidence after his death, if it be against his interest, and such an entry will be received as evidence of collateral and independent matter, etc. When the question was as to the age of a child, the book of the accoucheur who attended the mother was produced. It contained an entry as follows: W. Fowden, Jr.'s wife, Filius circa hor, 3 post merid nat, etc. W. Fowden, 1768, April 22, Filius natus wife, £1 6 and a penny, paid. 25 October 1768. The word paid was against the pecuniary interest of the accoucheur, so the entry was admitted to prove the date of the birth. In England the rule is thus laid down as to excluding experts from the room during the examination of witnesses. Medical or other professional witnesses who are summoned to give scientific opinions upon the circumstance of the case as established by other testimony will be permitted to remain in court until this particular class of evidence commences, but then, like ordinary witnesses, they will have to withdraw, and to come in one by one, so as to undergo a separate examination. A similar rule prevails in Scotland and in the United States. It would seem that the court has power to limit the number of experts in any case. Taylor, in his well-known work on medical jurisprudence, lays down many valuable suggestions for the guidance of medical witnesses. Among other things, he says, in reference to facts, a medical witness must bear in mind that he should not allow his testimony to be influenced by the consequences that may follow from his statement of them, or their probable effect on any case which is under trial. In reference to opinions, their possible influence on the fate of a prisoner should inspire caution in forming them, but, when once formed, they should be honestly and candidly stated, without reference to consequences. The questions put on either side should receive direct answers from the medical witness, and his manner should not be perceptibly different whether he is replying to a question put by the counsel for the prosecution or for the defence. The replies should be concise, distinct, and audible, and except where explanation may be necessary, they should be confined strictly to the terms of the question. Answers to questions should be neither ambiguous, undecided, nor evasive. The replies should be made in simple language, free from technicality. A medical witness may, without any imputation upon his bona fides, explain medical points to counsel, and correct him on medical subjects when wrong in his views or statements, but he should avoid even the appearance of prompting counsel in the conduct of the case. End of section 7. Recording by Ian Stewart, Rosanna, Victoria, Australia. Section 8 of the Law and Medical Men. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Ian Stewart, Rosanna, Victoria, Australia. The Law and Medical Men by Robert Vashon Rogers. Section 8. Chapter 8. Medical Experts. Whenever the subject matter of a legal inquiry is such that, from its partaking of the nature of a science, art, or trade, inexperienced persons are unlikely to prove capable of forming a correct judgment upon it without assistance, then the opinions of witnesses possessing peculiar skill and knowledge in the matters in question are admissible in courts of justice, and it is only when the matter inquired of lies within the range of the peculiar skill and experience of the witnesses, and is one of which the ordinary knowledge and experience of mankind does not enable them to see what inferences should be drawn from the facts, that the skilled witnesses may supply opinions as their guide. The rule admitting the opinions of experts in such cases is founded on necessity, for juries are not selected with any view to their knowledge of a particular science, art, or trade requiring a course of previous study, experience, or preparation. The rule of law on which the giving in evidence the opinion of witnesses, who know nothing of the actual facts of the case, is founded, is not peculiar to medical testimony, but is as a general rule applicable to all cases where the question is one depending on skill and science in any particular department. In general, it is the opinion of the jury which is to govern, and this is to be formed upon the proof of the facts laid before them. But some questions lie beyond the scope of the observation and experience of men in general, yet are quite within the observation and experience of those whose peculiar pursuits and profession have brought the class of facts frequently and habitually under their consideration. When, therefore, a question arises in a court of justice upon any such subject, and certain facts are proved by other witnesses, one skilled in such subject may be asked his opinion as to the character of such facts, or he may be asked his opinions on certain facts observed by himself. This is true with regard to any question of science, because persons conversant with such science have peculiar means, from a larger and more exact observation and long experience in such department of science, of drawing correct inferences from certain facts observed by themselves or testified to by other witnesses. The opinion of such witnesses is designed to aid the judgment of the jury in regard to the influence and effects of certain facts which lie out of the observation and experience of persons in general. These witnesses are called experts. This term seems to imply both superior knowledge and practical experience in the art or profession, but generally nothing more is required to entitle one to give testimony as an expert than that he has been educated in the particular art or profession, for persons are presumed to understand questions pertaining to their own profession or business. The practice of admitting the evidence of experts is an old one. In the Roman law they are frequently alluded to, and in the earliest common law reports they are spoken of as of established usage. Says Saunders J. And first I grant that if matters arise in our law which concern other sciences or faculties, we commonly apply for the aid of that science or faculty which it concerns. In a case of mayhem, the defendant prayed the court that the wound might be examined. on which a writ was issued to the sheriff to cause to come medicos chirurgos de melioribus London ad informandum dominum regum et curium de his quae eius ex parte domini regis injungerentur. Some judges and writers have very little respect for the evidence and opinions of experts. An Iowa judge says, observation and experience teach that the evidence of experts is of the very lowest order and of the most unsatisfactory kind. One from Maine speaks of the vain babblings and oppositions of science so called, which swell the record of the testimony of experts when the hopes of a party depend rather upon mystification than enlightenment. An Illinois judge quotes a distinguished occupant of the bench as saying, if there was any kind of testimony not only of no value, but even worse than that, it was in his judgment that of medical experts. Lord Campbell said, hardly any weight is to be given to the evidence of what are called scientific witnesses. They come with a bias on their minds to support the cause in which they are embarked. Taylor says, perhaps the testimony which least deserves credit with a jury is that of skilled witnesses. Being zealous partisans, their belief becomes synonymous with faith as defined by the Apostle, and it too often is but the substance of things hoped for, the evidence of things not seen. On the other hand, Best says, it would not be easy to overrate the value of the evidence given in many difficult and delicate inquiries, not only by medical men and physiologists, but by learned and experienced persons in various branches of science, art, and trade. And many judges have spoken of the essential aid to courts and juries rendered by the opinion of the experienced, skilful, and scientific witness who has a competent knowledge of the facts involved. When one takes his place as an expert before a court, a legal paradox is instituted on his behalf, by which he is allowed to testify, not as to what he knows, but to what he believes or forms an opinion upon, based necessarily on probabilities of analogy as well as experience. Nothing is required, in the absence of any statutory provision to the contrary, to entitle anyone to give evidence as a medical witness, than that he has been educated in the science of medicine. And this he may be by study without practice, or by practice without study. It is not necessary that he should be a physician, or have studied for one, nor be a graduate, nor one licensed to practice, nor need he be or have been a practitioner. One may be competent to testify as an expert, although his special knowledge of the particular subject of inquiry has been derived from the reading and study of standard authorities, and not from experience or actual observation. But one cannot qualify himself as an expert in a particular case merely by devoting himself to the study of authorities for the purposes of that case, when such reading and study is not in the line of his special calling or profession, and is entered upon to enable him to testify in the case. In Vermont, however, it has been held that mere education as a physician, without some practice as such, is insufficient to qualify one as an expert, and in Arkansas it is said that competency must be shown from study and experience. In New York it has been held that one otherwise qualified, who is a physician and surgeon, may give evidence, although not in full practice at the time. This fact merely goes to affect his credit. It is not necessary that the physician should have made the particular disease involved in the inquiry a specialty. Medical men of practice and experience are experts, and their opinions are admissible in evidence upon questions that are strictly and legitimately embraced in their profession and practice. If one has made the matter in question a specialty, doubtless his opinion will be of more value than if he has not, and it has been said that one who has devoted himself exclusively to one branch of his profession cannot give evidence as an expert on another. For example, one not an oculist may speak as to the cause of injuries to the eye. One who has not made diseases of the mind a special study may give his opinion as to the existence of insanity. One not a practical chemist or analyst, but understanding the practical details of chemistry and the means of detecting poisons, may testify as to the test in the chemical analysis of a stomach, and as to the tests usually applied to detect poison. The law will even allow a physician to speak as to the length of time a mule has been suffering from a disease, but one who has no experience as to the effect upon health of illuminating gas cannot testify in relation thereto as an expert, Nor can one who has for 30 years been exclusively treating the insane be permitted to testify as an expert on the mental capacity of a person in the last stages of disease who has not been previously insane. To render the opinion of a witness competent evidence, he must, in general, be in some way peculiarly qualified to speak on the subject, and have knowledge not possessed by the mass of persons of ordinary experience and intelligence. Upon this principle, a priest, who had studied physiology and psychology, in order that he might pass upon the mental conditions of communicants in his church, and who had so to decide daily, was permitted to speak as to the mental state of a woman whom he had attended in her last illness. It is a question of fact to be decided at the trial by the court whether a witness offered as an expert has the necessary qualification, and the matter cannot be referred to the decision of the jury. The decision of the judge at the trial will not be interfered with by the court, except in a clear and strong case. Anyone offered as an expert who cannot establish the fact of special knowledge or skill in the particular department which he is called upon to illuminate will be rejected. A court, before permitting an expert to testify, may examine him or hear evidence to satisfy itself that the witness is really what he assumes to be. We find no test laid down, says the Supreme Court of Indiana, by which we can determine with mathematical precision just how much experience a witness must have had, how expert, in short, he must be to render him competent to testify as an expert. But it is for the court to decide, within the limits of a fair discretion, whether the experience of the proposed expert has been such as to make his opinions of any value. Mere opportunities for special observation will not be deemed sufficient. While the court or judge determines the competency of the witness to testify as an expert, the weight to be accorded to his testimony is for the jury to decide. The testimony of an expert is to be weighed and tested like any other kind of evidence, and is to receive just such credit as the jury may think it entitled to. It is intended to enlighten their minds, not control their judgment. The jury are not bound by the opinions of medical experts. They may weigh their opinions like any other evidence. They may act against the greater number of opinions and in favour of the fewer. They may act against the greater number of opinions and in favour of the fewer, for the opinion of one expert may, on account of his greater knowledge and experience on the subject, or from his giving further details of the case, or more probable reasons for his opinion, to be of greater value to the jury than the opposite opinions of several. Ordronaux holds that a physician, though confessedly possessing the ordinary experience of his profession, may quoad some particular problem in medical science not to be an expert in the best and most critical sense of the term. Non omnes omnia possimus, once received as an expert. The maximum Culibert, in sua arte perito credendum est, must be applied, and he cannot be contradicted by any unskilled person. In 1869, the Chief Justice of the Kentucky Court of Appeal well said that the opinions of experts not founded on science but on a mere theory of morals or ethics, whether given by professional or unprofessional men, are wholly inadmissible as evidence. Hence the opinion of even physicians that no sane man in a Christian country would commit suicide, not being founded on the science or phenomena of the mind, but rather a theory of morals, religion, and future responsibility, is not evidence. In the matter of expert testimony, as in other matters, the law does not recognize any particular school of medicine to the exclusion of others. The popular axiom that doctors differ is as true now as ever it was, and so long as it continues to be so, it is impossible for the law to recognize any class of practitioners or the followers of any particular system or method of treatment as exclusively entitled to be regarded as doctors. The physician called to give evidence as an expert should understand at the outset that he is not called to express any opinion upon the merits of the case, but only on some questions of science raised by the facts proved, that he has no concern in the issue of the trial, and that whichever side calls him, he is in no wise the witness, much less the advocate, of that side. He is truly an adviser of the court, an amicus curiae, rather than a party interested in the result of the trial. Balbus, in his commentaries on the Code, says, Medici propriae non sunt testis, sed est magis judicum quam testimonium. Experts, no matter on what they testify, simply supply data as to whose competency, relevancy and weight the court is to judge, and as to which the court is finally to declare the law. Where the facts testified to by experts are undisputed, and when they are the results of a particular science or art with which such experts are familiar, then the court accepts such facts, and declares the law that therefore springs. Where the facts are disputed, then the jury is to determine where the preponderance of proof lies. But when the testimony of the expert touches either law or speculation, psychology or ethics, then such testimony is to be received as mere argument, which, if admissible at all, is to be treated simply as if addressed to the judgment of the court. In his examination in chief, an expert may not only give his opinion itself, but also the grounds and reasons of it. In fact, it has been held that it is his duty to state the reasons of his opinion and the facts on which it is based, and if it is not sustained by them, it is entitled to little weight. The opinion of a medical man is admissible upon the condition of the human system at any given time, the nature and symptoms of disease, the nature and effects of wounds, the cause of death, the cause or effect of an injury, the character of the instrument with which a wound was produced, the effect of a particular course of treatment, the likelihood of recovery, the mental condition of a person, and on similar subjects. For instance, where one was indicted for endeavouring to procure abortion, the opinion that the woman was pregnant at the time is relevant. Where the question was whether a certain blow was sufficient to cause death, or whether a wound and fracture on the head was caused by a fall, or whether the fractures of the skull were caused by a gun, or whether a gunshot wound caused death, the opinions of physicians were held admissible. The opinion of medical experts will be received upon the question as to whether an abortion has been performed, or whether certain drugs are abortives, or certain instruments adapted to produce an abortion. Experts may testify, after having made a chemical analysis of the contents of the stomach, as to the presence of poison in the body, and, without such analysis of a mixture, a chemist may speak of its ingredients. Those accustomed to make chemical and microscopic examination of blood and blood stains may speak as to whether certain stains are made by human or other blood. So, too, they may speak as to the ink in questions as to handwriting. So, too, they may be asked their opinions touching the permanency of any injury forming the subject of an action. Also, in an action for damages against a railway company, a physician may be asked at what period after the injury the plaintiff would be most likely to improve, if he were going to recover at all. Where Barber sued Merriam for injury to his wife, and she had been treated professionally for some weeks by Dr. H., the opinion of another physician as to the effect of Dr. H.'s treatment was considered admissible. And so in a case of malpractice, a medical man may be asked whether the practice pursued was good practice. He may be asked as to the nature and properties of the medicines employed by another physician in the case in question. Also as to the practice with regard to consultations. Also whether, in his opinion, a patient's death was or was not the result of neglect or want of skill on the part of the attending physician. But he cannot be asked his opinion as to the general skill of the physician on trial, nor the general reputation of the school which the doctor in trouble attended, nor can he say whether, from all the evidence in the case, the defendant was guilty of malpractice, for that is the question for the jury. Nor can he say whether a physician has honourably and faithfully discharged his duty to his professional brethren. It has been held that a medical witness may give his opinion upon new and hitherto unknown cases, whenever he swears that he can form such an opinion, even though at the same time he should admit that precisely such a case had never before fallen under his observation, nor under his notice in the books. The man of science is distinguished from the empiric in nothing more than in not relying on specifics, and also not waiting for the exact similitudes in things material and immaterial before forming a judgment as to their similarity. It must always be remembered that medical men, when called as skilled witnesses, may only say what, in their judgment, would be the result of certain facts submitted to their consideration, and may not give an opinion as to the general merits of the case, nor on the very point which the jury has to determine, nor on things with which a jury may be supposed to be equally well acquainted. As a recent writer puts it, a medical man cannot testify as to matters not of skill in his profession, nor conclusions nor inferences which it is the duty of the jury to draw for themselves. For instance, it was held that in a trial for murder, the opinions of the surgeons as to the probable position of the deceased when he received the blows which caused his death are incompetent. The judge said that he was not aware that surgeons were experts in the manner of giving blows of the description in question, or determining how the head must be placed so as most conveniently to receive them. Whenever the subject matter of the inquiry is of such a character that it may be presumed to lie within the common experience of all men of common education, moving in ordinary walks of life, the rule is that the opinions of experts are inadmissible, as the jury are supposed, in all such matters, to be entirely competent to draw the necessary inferences from the facts spoken of by the witnesses. Nor was the opinion of a medical witness admitted where the question, in an action for libel, was whether a physician, in refusing to consult with the plaintiff, had honourably and faithfully discharged his duty to the medical profession. The judge said, the jury having all the facts before them were as capable of forming a judgment upon that point as the witness himself. Nor can an expert give an opinion of the opinion of another expert. A medical man is considered an expert on the subject of the value of medical services, but he is not so considered when the question is one as to the amount of damages for a breach of contract not to practise physic in a certain town. The rule as to excluding experts from the courtroom during the examination of witnesses has been laid down in England thus: medical or other professional witnesses who are summoned to give scientific opinions upon the circumstances of the case as established by other testimony will be permitted to remain in court until this particular class of evidence commences, but then, like ordinary witnesses, they will have to withdraw, and to come in one by one, so as to undergo a separate examination, and in the United States the principle is similarly stated. End of section 8. Recording by Ian Stewart, Rosanna, Victoria, Australia.
Chapter 9 of the Law and Medical Men. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Linda Marie Nielsen, Vancouver, BC. The Law and Medical Men by Robert Vashon Rogers. Experts in Insanity Cases. The opinion evidence of the medical men in questions of insanity is not, as a rule, looked upon with any very great degree of favour by the courts who have to decide upon the competency, relevancy, and weight of the opinions uttered. Chapman, C.J. of Massachusetts, in charging a jury, said: "While they afford great aid in determining facts, it often happens that experts can be found to testify to anything however absurd." In another insanity case, another judge remarked: "Experience has shown that opposite opinions of persons professing to be experts may be obtained to any amount, and it often occurs that not only many days but many weeks are consumed in cross-examinations, to test the skill and knowledge of such witnesses, and to test the correctness of their opinions." This was the case to a great degree in the well-known Guilleneau prosecution, thus wasting time and wearying the patience of both court and jury, perplexing instead of elucidating the question involved in the issue. As to the perplexing instead of elucidating, a writer of the highest authority gives the following: In a case of alleged child murder, a medical witness, being asked for a plain opinion of the cause of death, said that it was owing to atelectasis and a general engorgement of the pulmonary tissue. And in a trial for an assault, a surgeon, in giving his evidence, informed the court that on examining the prosecutor he found him suffering from a severe contusion of the integument under left orbit, with great extravasation of blood and ecchymiosis in the surrounding cellular tissue, which was in a tumefied state, and there was also considerable abrasion of the cuticle. The judge said, "You mean, I suppose, that the man had a bad black eye." "Yes." "Then why not say so at once?" Redfield C.J., in his book on Willis, says, "Experience has shown both here and in England that medical experts differ quite as widely in their inferences and opinions as do other witnesses. This has become so uniform a result with the medical experts of late that they are beginning to be regarded much in the light of hired advocates, and their testimony as nothing more than a studied argument in favor of the side for which they have been called. So uniformly has this been proved in our experience that it would excite scarcely less surprise to find an expert called on one side testifying in any particular in favor of the other side, than to find the counsel upon either side arguing against their clients and in favor of their antagonists. A Lord Chancellor once remarked that his experience taught him that there were very few cases of insanity in which any good came from the examination of medical men. Their evidence sometimes adorned a case, and gave rise to very agreeable and interesting scientific discussions, but after all they have little or no weight with the jury. And Mr. Justice Davies, of the Supreme Court of Maine, after stating that he thought juries far more trustworthy than experts on the subject of insanity, said, "If there is any kind of testimony that is not only of no value but even worse than that, it is in my judgment that of medical experts. They may be able to state the diagnosis of the disease more learnedly, but upon the question whether it had, at a given time, reached such a stage that the subject of it was incapable of making a contract, or irresponsible for his acts, the opinion of his neighbors, if men of good common sense, would be worth more than that of all the experts in the country." There is scarcely a simple hypothesis as to the responsibility on the part of the insane, no matter how wild, which among the large number of experts who have concerned themselves with this branch of study has not its advocates. So says Wharton in his valuable treatise on mental unsoundness, or as Cicero elegantly put it long ago, "Nihil tam absurde disi potest, quod non dictor ab aliquo philosophorum." Considering these things, one is not surprised at Campbell C.J. in the Bainbridge case, saying to three medical men who had recorded their opinions in favor of the insanity of the testator, "You may go home to your patients, and I wish you may be more usefully employed there, than you have been here." And to the jury he remarked, "We have had during the trial the evidence of three medical witnesses, and I think they might as well have stayed at home and attended to their patients." On the other hand, Shaw, C.J., said, "Such opinions, as to sanity, etc., when they come from persons of experience, and in whose correctness and sobriety of judgment just confidence can be had, are of great weight, and deserve the respectful consideration of a jury. But the opinion of a medical man of small experience, or of one who has crude and visionary notions, or who has some favorite theory to support, is entitled to very little consideration. The value of such testimony will depend mainly upon the experience, fidelity, and impartiality of the witness who gives it. And Chief Justice Gibson speaks with just emphasis on the deference due, in their own department, to the knowledge obtained by men of a subject with which they have grappled all their lives. The Supreme Court of Texas declared, "The opinions of medical men on questions of insanity are received with great respect and consideration, and properly so." The Supreme Court of Pennsylvania says, "It is well settled that the knowledge and experience of medical experts is of great value in questions of insanity." Equally strong are the utterances of the Court of Appeals of West Virginia and the Supreme Court of North Carolina. When the point in question is the sanity of a person, the opinion of a medical man on the subject is, of course, admissible when that opinion is drawn from personal observation. This is the rule both in England and the United States. But a medical man may also give his opinion on this subject, even though he has no knowledge of the person whose sanity is in question. It has been suggested that when a physician is asked his opinion on the facts stated by other witnesses, he should be first examined as to the particular symptoms of insanity, and as to whether all or any and which of the circumstances spoken of by the witnesses upon the trial are to be regarded as such symptoms. Then inquire of him whether any and what combination of these circumstances would, in his opinion, amount to proof of insanity. It has been held to be improper to ask a medical witness whether the person, whose sanity was in question, possessed sufficient capacity to make a will, or to transact business, as these are matters of law, depending on the nature of the business. In England such witnesses can only speak as to the state of mind, not as to the responsibility of a prisoner. This latter point is for the jury under the direction of the judge. So, on the plea of insanity at the time of making a contract, the opinion of the medical man who gave the certificate on which the defendant was confined as insane at or about the time, is only evidence for the jury, who must judge of the grounds upon which it was formed. In England an expert cannot be asked, after being present at the whole trial, whether the defendant was insane, or whether the act complained of was an insane act, because these are questions for the jury and the witness must not be placed in the jury's place; but he may be asked whether such and such appearances, proved by other witnesses, are in his judgment symptoms of insanity. The particular facts proven by other witnesses may be taken and the expert may be asked, "Assuming these facts to be true, do they in your judgment indicate insanity on the part of the defendant at the time the alleged act was committed?" As a rule the court should not allow an expert to give his opinion upon facts proved by a witness unless he has heard all the testimony of the witness, because the entire testimony may be necessary in order to enable him to form an opinion in regard to the subject matter of inquiry. Where the facts are disputed, experts can only be questioned as to their opinion of a party's sanity on a hypothetical case, or as to certain designated facts existing in the case supposing them to be true. The mode in which this hypothetical question is to be put has been much considered. In England, in the celebrated Macnaghten case, in answer to an inquiry of the House of Lords, whether a medical man conversant with the disease of insanity, who never saw the prisoner previously to the trial, but who was present during the whole trial and the examination of the witness can be asked his opinion as to the state of the prisoner's mind at the time of the commission of the alleged crime, or his opinion whether the prisoner was conscious at the time of doing the act that he was acting contrary to the law, or whether he was laboring under any and what delusion at the time. The 12 judges replied, "We think the medical man, under the circumstances supported, cannot in strictness be asked his opinion in the terms above stated, because each of those questions involves the determination of the facts disposed to, which it is for the jury to decide, and the questions are not mere questions upon a matter of science, in which case such evidence is admissible, but where the facts are admitted or not disputed, and the question becomes substantially one of science only, it may be convenient to allow the question to be put in that general form, though the same cannot be insisted on as a matter of right." In Massachusetts Chief Justice Shaw said, "The proper question to be put to the professional witness is this: If the symptoms and indications testified to by the other witnesses are proved, and if the jury are satisfied of the truth of them, whether in their opinion the party was insane, and what the nature and character of the insanity, what state of mind did they indicate, and what they would expect would be the conduct of such person in any supposed circumstance." In another well known case, the judge said to the jury, "It is not the province of the expert to draw inferences of facts from the evidence, but simply to declare his opinion on a known or hypothetical state of facts, and therefore the counsel on each side have to put to the physicians such states of fact as they deem warranted by the evidence, and have taken their opinions thereon. If you consider any of these states of facts put to the medical witnesses are proved, then the opinions thereon are admissible evidence to be weighed by you, otherwise their opinions are not applicable to the case." The opinions of both experts and non-experts should have weight according to their opportunities and qualifications for examinations of the state of mind of the person whose sanity is in question. First of all will be the family, or the physician, who has attended the patient through the disease which is supposed to have disabled his mind. Next are those who, without special learning on the subject, have had the best opportunities for judging, the members of his family, and those whose intimacy in the family have given them opportunities of seeing the patient at all times and noticing the alienation of his mind. And last come those who only occasionally and at intervals have seen him, and whose chances of studying his moods have been small. It has been held, in Massachusetts, that a physician who has not made insanity a special subject, and who when consulted in such matters always called in a specialist, is not competent to give an opinion on a hypothetical case put to him, unless he was the person's attending physician. Then his opinion is received, and it is his duty to make himself acquainted with the peculiarities, bodily and mental, of a person who is the subject of his care and advice. And where a physician had for more than 30 years been exclusively treating the insane, he was not permitted to testify, as an expert, to the mental capacity of a person, not previously insane, who was in the last stages of disease. One not an expert may give an opinion, founded on observation, as to whether a person is sane or insane, notwithstanding the general rule that persons not medical men cannot give their opinions as to the existence, nature, or extent of disease in any one. The exception was first introduced in regard to the subscribing witnesses to a will, who were permitted to speak as to the testator's state of mind. It has now been extended to all cases where the witness' acquaintance with the party whose sanity is in dispute, or his means of observation, are sufficient to enable him to express his opinion as to the mental condition. The courts of Massachusetts, Maine, New Hampshire, and Texas, however, still adhere to the old rule and admit the evidence of non-experts only in cases of wills. End of chapter. Experts in Immunity Cases. Recorded by Linda Marie Nielsen, Vancouver, BC. Chapter 10 of the Law and Medical Man. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Linda Marie Nielsen, Vancouver, BC. Law and Medical Men by Robert Vashon Rogers. Defamation. No man may disparage the reputation of another. Every one has a right to have his good name maintained unimpaired. Words which produce any perceptible injury to the reputation of another are called defamatory, and if they are false they are actionable. False and malicious defamatory words, if in printing, writing, pictures, or signs, and published, constitute a libel; if spoken, a slander. A caricature may be a libel; so may a chalk mark on a wall, a statue, hieroglyphics, a rebus, an anagram, or an allegory, or even ironical praise. Defamatory matter, whether published in the form of libel or slander, is actionable when it imputes a criminal offense, or a contagious or infectious disorder, or affects the plaintiff injuriously in his lawful profession, trade, or business, or in the discharge of a public office, or generally when is false and malicious, and its publication causes damage to the plaintiff either in law or in fact. Defamatory matter, the publication of which tends to degrade or disparage the plaintiff, or which renders him ridiculous, or charges him with want of honesty, humanity, or veracity, or is intended to impair his enjoyment of society, fortune, or comfort, is actionable as libel, but not as slander unless special damage be proved. The person defamed by a libel has not only a civil remedy to recover damages, but he may also, in some cases, proceed criminally by way of information or indictment and have the defamer punished as an offender against the state. If he proceeds by information he must in general waive his right to bring a civil action, but he may sue for damages after the offender has been convicted upon an indictment. An action for libel must be brought within 6 years, and an action for slander within 2 years, unless the words spoken are actionable only by reason of special damage, in which case the action may be brought at any time within 6 years. Whenever a special kind of knowledge is essential to the proper conduct of a particular profession, denying that a man possesses such special knowledge will be actionable if he belongs to that particular profession, but not otherwise. Thus to say of a physician, "Thou art a drunken fool and an ass, thou wert never a scholar, nor even able to speak like a scholar," is actionable, because no man can be a good physician unless he be a scholar. Although one may with impunity say of a justice of the peace, "He is a fool, an ass, and a beetle headed justice," so to say of a midwife, "Many have perished for her want of skill," or, "She is an ignorant woman, and of small practice and very unfortunate in her way. There are few she goes to but lie desperately ill, or die under her hands," is actionable. Or of an apothecary, "He is not an apothecary, he has not passed any examination, several have died that he has attended, and there have been inquests held about them." Although one may safely say of a justice of the peace, "He is a blood sucker, and sucketh blood." It is actionable to say of a person in his professional character, "He is no doctor, he bought his diploma for $50." Any words imputing to a practising medical man misconduct or incapacity in the discharge of his professional duties are actionable per se. Thus, it is actionable without proof of special damage, to accuse one of having caused the death of any patient through his ignorance or culpable negligence, as to say of a physician, "He killed my child by giving it too much calomel," or, "He hath killed J.S. with physic, which physic was a pill," or, "He was the death of J.P. He has killed his patient with physic. It is a world of blood he has to answer for in this town through his ignorance. He did kill a woman and two children at Southam. He did kill J.P. at Petersfield." Or, as an American did, "Dr. S. killed my children. He gave them teaspoonful doses of calomel, and it killed them. They did not live long after they took it. They died right off the same day." So it is to say of an apothecary, "He poisoned my uncle. I will have him digged up again, and hang him." Or, "He killed my child. It was the saline injection that did it." Or, "I was told he had given my child too much mercury, and poisoned it. Otherwise it would have gone well." So it is actionable to say of a surgeon and accoucheur, "It is a bad character. None of the medical men here will meet him." As such words impart the want of a necessary qualification for a surgeon in the ordinary discharge of his professional duties. Or, "Dr. Tweedie has honorably and faithfully discharged his duties to his medical brethren in refusing to act or consult with Ramdaj, a physician, and we hope every one else will do the same." Or to call a practising medical man a quack, a quacksalver, an empiric, or a mountebank. Or to say of him, "Thou gravest physic, which thou knewest to be contrary to the disease," or, "Thou art no good subject, for thou poisonedst A.F.'s wound, to get more money of him." Under the New York statutes, a homœopathic physician may maintain any action for being called a quack, and it seems that an action will lie, without averment of special damages, for slander imputing to a physician, that he has taken advantage of his character as a physician to abuse the confidence reposed in him, and commit acts of criminal conversation with a patient. In the case of libel, any words will be presumed defamatory which expose the plaintiff to hatred, contempt, ridicule, or obloquy, which tend to injure him in his professional trade, or cause him to be shunned or avoided by his neighbors. Thus, to advertise falsely that certain quack medicines, consumption pills, were prepared by a physician of eminence, is a libel upon such physician. Whenever a medical man brings forward some new method of treatment, and advertises it largely as the best or only cure for some particular disease, or for all diseases at once, he may be said to invite public attention, and a newspaper writer is justified in warning the public against such advertisers, and in exposing the absurdity of their professions, provided he does so fairly and with reasonable judgment. A medical man who has obtained a diploma and the degree of M.D. from an American college, advertised in England most extensively a new and infallible cure for consumption. The Pall Mall Gazette published a leading article on these advertisements, in which they called the advertiser a quack and an impostor, and compared him to scoundrels who pass bad coin. This was considered as overstepping the limits of fair criticism, and a verdict was given for the plaintiff, with damages 1 farthing. So where the editor of the Lancet attacked the editor of a rival paper, the London Medical and Physical Journal, by rancorous aspersions on his private character, not fairly called for by what the plaintiff had done as an editor, the plaintiff recovered a verdict of £5. On the other hand, it is not actionable to say of a surgeon, he did poison the wound of his patient, without some averment that this was improper treatment, for it might be proper for the cure of it; nor to say of an apothecary, he made up the medicine for my child wrong, through jealousy, because I would not allow him to use his own judgment; nor to charge a physician or surgeon with malpractice, if it appear that the word was not used or understood in a technical sense; and to charge a physician or surgeon with mere want of skill, or with ignorance or neglect, is not actionable per se, though untrue, unless the charge be of gross want of skill, or the like, so as to imply general unfitness. Nor is it actionable to call a person who practises medicine or surgery without legal qualification a quack or an impostor, for the law only protects lawful employment. Even though a medical man may be duly registered in Great Britain, still, if he is practising in a colony which requires registration without complying with the colonial law, he may safely be called a quack, a charlatan, a scoundrel not to be entrusted with the lives of people. Words imputing immoral conduct, profligacy, or adultery, even when spoken of one holding an office or carrying on a profession or business, are not actionable unless they touch him in that office, profession, or business. Thus, if adultery is alleged of a clergyman, it will be actionable, because if the charge were true, it would be ground for degradation or deprivation, as it would prove him unfit to hold his benefice, or to continue the active duties of his profession. But if the same words are spoken of a physician, they will not be actionable without proof of special damage, as they do not necessarily affect the plaintiff in relation to his trade or profession. Nor unless the words are spoken in connection with the professional duties of the plaintiff will an action lie for the words, "He is so steady drunk, he cannot get business any more," or "He is a twopenny bleeder." It is no libel to write of a physician that he is in the habit of meeting homeopathists in consultation. Where the plaintiff considers that the words spoken touch him in his profession or trade, he must always aver in the pleadings that he was carrying on the profession of a physician or surgeon, or the trade of a druggist, at the time the words were spoken. Sometimes this is admitted by the slander itself, and if so, evidence is of course unnecessary in proof of this averment. But in other cases, unless it is admitted on the pleadings, evidence must be given at the trial of the special character in which the plaintiff sues. As a rule, it is sufficient for the plaintiff to prove that he was engaged in the profession or trade, without proving any appointment thereto, or producing a diploma or other formal qualification. For the maxim omnia presumere ret esse acta applies. But if the very slander complained of imputes to the medical practitioner that he is a quack or an impostor, not legally qualified for practice, or if the plaintiff aver that he is a physician and has duly taken his degree, then the plaintiff at the trial must be prepared to prove his qualification strictly by producing his diploma or certificate. In some cases the mere production of the diploma will not be sufficient proof of the plaintiff's having the degree, but it may be necessary to prove that the seal affixed is the seal of a university having power to grant degrees, or in the case of the production of a copy of the diploma, that it has been compared with the original. Whether or no the words were spoken of the plaintiff in the way of his business is a question for the jury to determine at the trial. There should always be an averment in the statement of claim, that the words were so spoken, and it should also be shewn in what manner the words were connected by the speaker with the profession. Medical practitioners are of course equally liable with other men to an action for defamation, in respect of any false and malicious communication, whether oral or written, made by them to the damage of another, in law or in fact. Circumstances, however, frequently arise where, from the nature of their employment, it becomes their duty or interest to make some communication prejudicial to the character or conduct of another, and in such cases, where the occasion on which the communication was made rebuts the presumption of malice, where the law infers from such a statement, such communication is said to be privileged, and therefore, in order to sustain an action for defamation, the plaintiff must prove that the defendant was actuated by express or actual malice, that is, malice independent of the occasion on which the communication was made. The legal canon is, that a communication made bona fide upon any subject matter in which the party communicating has an interest, or in reference to which he has a duty, is privileged, if made to a person having a corresponding interest or duty, although it contains criminatory matter which without this privilege would be slanderous and actionable. This applies moreover though the duty be not a legal one, but only a moral or social duty of imperfect obligation, and also where the communication is made to a person not in fact having such interest or duty, but who might reasonably be, and is supposed by the party making the communication to have such interest or duty. Even where the evidence of duty is not present to the mind, but the speaker is impelled by a sense of propriety on which he does not pause to reflect, and which he refers to no special motive, nevertheless, if his conduct in speaking the words be within the occasion of interest or of duty which is capable of protecting, the communication will be considered privileged. Words spoken by the medical officer of a college concerning the meat furnished to the institution, and words used by the medical attendant of a poor law union about the wine supplied to the inmates, are privileged, in the absence of proof of actual malice. A statement made by a physician that an unmarried woman is pregnant is not a privileged communication, unless made in good faith to one who is reasonably entitled to receive the information. End of chapter 10. Recording by Linda Nielsen, Vancouver, BC.
Chapter 11 of The Law and Medical Men. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Law and Medical Men by Robert Vashon Rogers. Chapter 11. Relations with Patients. It is a well-settled doctrine that where one occupies a position which naturally gives him the confidence of another, or which in any way gives him an influence or an undue advantage over the other, transactions between them require something more to give them validity than is necessary in other cases. The mere fact of the existence of such a relationship as naturally creates influence over the mind will lead the courts to infer the probability of undue influence having been exerted. Confidence has been held to imply the opportunity for influence, and when established, dispenses with any more direct proof of influence. In such cases, the onus is cast upon the person occupying such a relationship to establish the perfect fairness and equity of the transaction. He must shew that the other acted after full and sufficient deliberation and with all the information that it was material for him to have, in order to guide his conduct, and that he had either independent and disinterested advice, or as ample protection as such advice could have given him. Lays it down that the donor must have had competent and independent advice. The relation between a medical man and his patient is one in which the probability of undue influence is inferred, and so, in dealing with their patients, the acts of physicians are watched with great jealousy, not because the court blames and discountenances the influence flowing from such relation, but because it holds that this influence should be exerted for the benefit of the person subject to it, and not for the advantage of the person possessing it. The discontinuance of the relationship is only material if the influence has ceased with the relation, and the relation does not necessarily cease because the patient has not medicine actually administered to him at the time. Where a surgeon and apothecary obtain from a patient 85 years old an agreement to pay him £25,000 in consideration of past medical services, duly charged and paid for, and the promise of future medical and surgical assistance until death without charge, and kept the matter concealed until after the death of the patient, the court, on the prayer of the patient's executor, ordered the medical man to give up the agreement to be cancelled. So, when an octogenarian patient conveyed by deed of gift a property worth £1,000 to his physician, who was also his intimate friend and the son of his benefactor, the court set aside the deed for fraud. In this case, the consideration named in this deed was not the true one, and even where a patient gave to his surgeon an annuity of £100 for the surgeon's life, in consideration that he would live with him and give him the benefit of his professional assistance during his, the donor's, life, it being shown that the surgeon had been told by an eminent physician, just before the deeds were drawn, that the patient could not recover or live long, and that the surgeon himself, about the same time, had said the patient could not live more than a month or so, the court held the instruments could not be maintained. A patient, aged, feeble, deaf, and of very weak mind, bestowed all his estate on the attending physician, who lived with him, and had controlling influence over him for an extremely trifling compensation. The transaction was set aside, the court saying, owing to the relation which the parties sustained toward each other, the deed was presumptively the result of undue influence, and therefore prima facie void for that reason. It has been repeatedly declared by learned chancellors that the mere relation of patient and medical adviser was sufficient to avoid the contracts that the former made with the latter during the continuance of such relation. a security given by an old man for £262 10 to a dentist in consideration of his old teeth being kept in order and new ones being supplied during the remainder of his life, had to be given up. And if a man pays an exorbitant bill to a doctor, the court will grant him relief, and it will be no answer to his asking his money back to say that he intended to be liberal, unless such intentions can be clearly shown. Even a sale to a patient by the medical man under whose care he is will be set aside if at an exorbitant price, and the purchaser has had no independent advice, but where the evidence showed that the patient's own attorney prepared the papers, that he had independent advice and understood what he was doing and exercised his free will, and that the medical man had long attended him, the court refused to set aside the deed, although the patient was 80 years of age. And although a gift made to a physician may be voidable because of his standing in a confidential relation to the donor, a patient, yet if after the confidential relation has ceased to exist, the donor intentionally elects to abide by the gift, and does in fact abide by it, it cannot be impeached after his death, even if it is not proved that the patient was aware that the gift was voidable at his election. There is, of course, nothing in the relation of medical attendant and patient which can prevent the one from entering into contract with the other, where the transaction proceeds openly and fairly, and the relation of physician and patient has, in reality, no bearing upon it. In the case of a sale by a patient to a physician, where there was no proof of inadequacy of price, the transaction was sustained. A strong case must be made to set aside a will on the ground of undue influence. Influence is not sufficient. There must be such a degree of influence as deprives the testator of the proper mastery over his faculties. To invalidate a will on the ground of undue influence, it must be shown that it was practiced with respect to the will itself, or so contemporaneously with the will, or connected with it, as by almost necessary presumption to effect it, and flattery and obsequiousness, however degrading, will not constitute such an undue influence as will affect the acts of a capable testatrix. Many wills made in favor of medical men by their patients have been sustained, although disputed, and even in cases where the patients have been aged, infirm women with impaired minds. A physician, however, may fail to obtain the benefits which a grateful patient has wished him to have under a will, if, as was done in one case, after a long attendance on a patient, he thinks fit, when she is almost on her deathbed, to prepare and procure the execution of a will by which he becomes the principal object of her bounty, to the exclusion of her near relatives, and to do this without the intervention of any solicitor or other person competent to give her advice and to guard her against undue influence, for in such a case the interests of the public require that his conduct should be regarded by courts of justice with the utmost jealousy. In another case it was said that although there is no rule of law which forbids a man to bequeath his property to his medical attendant, yet it is not a favorable circumstance for one in such a confidential position, with respect to a patient laboring under a severe disease, to take a large benefit under such a patient's will, more particularly if it be executed in secrecy, and the whole transaction assumes the character of a clandestine proceeding, and in such a case the onus will lie very heavily upon the party benefited to maintain the validity of the will. Clairvoyant physicians may also get into trouble. An action was brought against one to set aside a marriage and conveyance of property worth $25,000. The patient was old, feeble, deaf, childish, and firm spiritualist. The clairvoyant was a woman who pretended to be very modest and bashful and able to cure the deafness. After a course of treatment, mainly by manipulation, she told the old man that the spirit said that they must be married within 2 weeks, or something dreadful would step in between them. By misrepresentations concerning her character and her friends, she won the old man and his property. After the honeymoon, the patient came to his senses and prayed to get back his liberty and possessions because of the fraud used. The court granted his prayer. To promise a cure is unprofessional, and to obtain money on the faith of such a promise is sometimes dangerous. Brown falsely represented himself to A, an ignorant Negro, to be a practicing physician, and that he had restored sight to the blind. He persuaded A that A's house was infected with poison, and that it was in the bed occupied by his granddaughter, that she was poisoned, and that he could remove the poison if he was paid for so doing. A gave him $22 to remove it. The court held that Brown had been guilty of obtaining money under false pretenses. A physician should take all possible care to prevent the spread of smallpox or any other contagious disease, and use all such precautionary measures as may appear desirable. So where the paper upon the walls of a room in which there had been smallpox patients had become so soiled and smeared with the smallpox virus as to make its removal necessary, a physician or other attendant may order the paper to be torn down, and the landlord cannot successfully maintain an action against the physician for doing this. Apparently, a surgeon may retain the limbs he cuts off a patient, upon the ground that parts of the body when severed become dead, and at common law there is no property in a dead human body. The point was once contested in Washington. A surgeon who attends a duel, although to save by his skill if possible the lives therein imperiled, will be held guilty of aiding and abetting the principal offender in the event of death ensuing. If a medical practitioner willfully injures a patient, he is liable to be indicted for an assault, and if death ensue from the injury so inflicted, he may be indicted for murder. And this is so even though the patient might have submitted at the time from the supposition that the treatment was for his good. Having or attempting to have carnal connection with a female patient under pretense of treating her medically is an assault. Making a female patient strip naked under pretense that the defendant, a medical practitioner, cannot otherwise judge of her illness, if he himself takes off her clothes, contrary to her wishes, is an assault. In this case, the jury found that the defendant had stripped the girl wantonly, and not from any belief that it was necessary. Where a physician takes an unprofessional, unmarried man with him to attend a case of confinement, and no real necessity exists for the latter's assistance or presence, both are liable for damages, and it makes no difference that the patient or her husband supposed at the time that the intruder was a medical man, and therefore submitted without objection to his presence, or that the intruder accompanied the physician reluctantly on a dark and stormy night to carry a lantern or umbrella and some instruments, and that there was only one room in the house. The court remarked, Dr. Demey therefore took an unprofessional young unmarried man with him, introduced and permitted him to remain in the house of the plaintiff, when it was apparent that he could not hear at least, if not see, all that was said and done, and, as the jury must have found under the instructions given, without either the plaintiff or her husband having any knowledge or reason to believe the true character of the third party, it would be shocking to our sense of right, justice, and propriety, even to doubt that for such an act the law would afford an ample remedy. To the plaintiff the occasion was a most sacred one, and no one had a right to intrude unless invited, or because of some real and pressing necessity, which is not pretended existed in this case. The plaintiff had a legal right to the privacy of her apartment at such time, and the law secures to her this right by requiring others to observe it and to abstain from its violation. The fact that at the time she consented to the presence of Scattergood, supposing him to be a physician, does not preclude her from maintaining an action and recovering substantial damages upon afterward ascertaining his true character. In obtaining admission at such a time and under such circumstances, without fully disclosing his true character, both parties were guilty of deceit, and the wrong thus done entitles the injured party to recover the damages afterward sustained from shame and mortification. Upon discovering the true character of the defendants, the action was brought by the wife. If physicians who have certified to the insanity of a person have not made the enquiry and examination which the statute requires, or if their evidence and certificate in any respect or form or substance are not sufficient to justify a commitment to an asylum, the authorities should not commit, and if they do it is their fault and not that of the physicians, provided the latter have stated facts and opinions truly and have acted with due professional care and skill. If a medical man takes upon himself the responsibility of imprisoning a person on the ground of insanity, upon mere statements made to him by others, he will be liable to an action, and also for an assault, unless he can indeed show that the party imprisoned was insane at the time. He is not liable for an assault if he has signed a certificate under the Lunacy Acts and has done nothing more towards causing the confinement of the alleged lunatic. A medical man or other person may justify an assault where it is committed for the purpose of putting a restraint upon a dangerous lunatic in such a state that it is likely he may do mischief to someone. In Ontario, except under order of the Lieutenant Governor, no one can be admitted into a lunatic asylum without the certificate of 3 medical men, each attested by the signatures of 2 subscribing witnesses. Their certificates must state a personal and separate examination, and that after due inquiry the patient was found insane, and that the physicians must also specify the facts upon which they formed their opinion of the insanity. In England, except in the case of paupers, 2 certificates are required. The practice of abortion is forbidden by the Oath of Hippocrates. The act is recognized as a crime in almost every code of medical ethics. Its known commission has always been followed by ignominious expulsion from medical fellowship and fraternity. At common law, a child in ventre samire is not considered a person, the killing of whom is murder, but if one, intending to procure abortion, causes a child to be born so soon that it cannot live, and it dies in consequence, it is murder. And it is murder if one, attempting to procure abortion, either by means of drugs or instruments, cause the death of the woman. In most civilized countries, it is now either a felony or grave misdemeanor to attempt to procure the miscarriage of a woman by any means, or to supply or procure anything knowing that it is intended to be unlawfully used or employed to procure a miscarriage. In some states, the crime of abortion may be committed at any stage of pregnancy. The thing prescribed must be noxious in its nature, but it is not necessary to prove that it will produce miscarriage. The burden of shewing that the use of instruments to produce abortion was necessary to save the life of the woman is on the accused. It is an indictable offense for a physician or anyone else unlawfully and injuriously to carry along or to expose in a public highway on which persons are passing and near to the habitations of others any person infected with the smallpox or any contagious disorder, and it is for the accused to shew that the object of the carrying or exposure was lawful. In England, since 1840, it has been an indictable offense to inoculate for the smallpox. So, too, it has been in Canada for a number of years. It has been held in the state of Alabama that where a special prohibitory act does not except the practicing physician from its operation, he is liable if he administers intoxicating bitters to his patient, but not for using liquors necessary in compounding medicine manufactured and sold by him. The application of any other rule, it was said by the court, would be fraught with difficulty, if not impracticability. So, too, in Kansas. Any registered practitioner who has been convicted of felony shall forfeit his right to registration, and the medical council may cause his name to be erased from the register, and if any one who has been convicted of felony presents himself for registration, the registrar may refuse registration. But one's name cannot legally be removed from the register without notice and an opportunity of being heard. A person who has met with personal injuries must exercise the same degree of care in the employment of a physician and surgeon, and in procuring and submitting to proper medical treatment as a prudent and reasonable man would in any other matter, for those persons liable for the original injury will not be responsible for the further damage arising from the improper selection of a physician. If a family doctor or the surgeon of a company or society, on leaving home, recommends in case of need some other physician who is not, however, in any sense in his employment, it does not make him in any way liable for injuries arising from the latter's want of skill. End of Chapter 11. Recording by L.T. Lesky.